But viewers, now we shift our gaze to the developments unfurling in Dhaka, and important developments at that. Now, in a sharp escalation, US Secretary General Antonio Guterres has in fact openly opposed the death penalty, or the death sentence in fact handed to former ousted Bangladesh Prime Minister Sheikh Hasina, who still remains in the Indian capital of New Delhi. Meanwhile, Guterres' office says that trials in absentia must meet international fair trial standards, also echoing human rights chief's warnings that even serious allegations cannot and must not bypass due process. Listen in.
While we were not privy to the conduct of this trial, we have consistently advocated for all accountability proceedings, especially on charges of international crimes, to unquestionably meet international standards of due process and fair trial. This is particularly vital when, as was the case here, the trials have been conducted in absentia and led to a capital punishment sentence. We also regret the imposition of the death penalty, which we oppose in all circumstances.
Well, you heard the UN spokesperson there, viewers. Meanwhile, Dhaka has already sought the handing over of Hasina from India. Now, this comes after Monday's death sentence. But how does this align with India's Extradition Act, especially as Bangladesh seeks Hasina's return, or is in fact demanding Hasina's return? The spotlight, viewers, is very much now on the exact powers the Extradition Act gives New Delhi, and of course, the limits it also imposes. So let's quickly take a stock of the same. First up for you, requests can be rejected. First up, centre can deny any extradition request on its discretion. So this essentially means that the Extradition Act, or the law in principle, allows New Delhi to very much decide if an extradition request even moves forward. It can halt or totally reject the process based purely on national interest. Next up, request rejected if politically motivated. Now, India can block any request seen as driven by a political vendetta, which seems clearly the case in this death sentencing against former Bangladesh Prime Minister Hasina. Now, the act also protects individuals from being targeted under the guise of justice. Next up, extradition refused for trivial accusations. Now, the centre, India in this case, may very well dismiss requests it finds too minor or insubstantial at that. Now, this prevents foreign governments from misusing extradition for low-level issues. Next up for you, government may stay proceedings anytime. As the point clearly mentions, Indian authorities at this juncture can very well pause the process, cancel warrants, or even discharge the accused. It gives the centre, the Indian government, tactical flexibility as situations evolve. And finally, political nature charges bar extradition. Now, the act also, viewers, very importantly here, I must mention, prohibits surrendering anyone and anyone facing a political offence. Now, the accused can very well prove the request is disguised as a political charge by an external government. Last but not the least, no extradition without offence safeguards. So India, by the way, requires assurances that the person will not be tried for unrelated crimes. Now, without such protections, the treaty forbids extradition altogether. Viewers, so as the diplomatic standoff continues to simmer, India's decision will hinge not on just politics here, but also on these legal firewalls built into its very extradition framework. For now, viewers, New Delhi's next move remains not only strategic, but also tightly governed by India's law. And to shed more light on this, I am joined by senior advocate Desh Ratan Nigam. Thank you so much for taking out the time and joining us on this important broadcast. So my first question to you, we've all seen the UN's warning, we just played it out. Now, can Bangladesh claim legitimacy in demanding Hasina's return under international law?
Arjun, in fact, if I put the entire issue in the context, the uprising there started as a civil services quota unrest, and judiciary gave a favorable verdict demolishing the quota, that particular freedom fighters quota. And thereafter, the entire protest became very political it became anti-Sheikh Hasina and anti-her party. And therefore, the entire issue became political. There was a political uprising in which it is said, and it is, I'm quoting the son of Sheikh Hasina, that she did not resign. She did not have the time to resign from the prime ministership, and she had to flee because the residence was attacked. Constitutionally, according to her son, she is still the prime minister. Therefore, the entire edifice of the legality and constitutionality of the interim government goes. Once that goes, the entire process also goes. However, presuming for the sake of argument that the interim government is there and it is legally there, then if you look at the treaty was enacted in 2013 between the two nations, India and Bangladesh, to deal with the terrorism.
Right, sir.
And the reason was that the war crimes which were committed during the 1971 war, they had to be dealt with, and also the Ulfa, terrorists who were hiding and their leaders who were hiding in Bangladesh. Primarily, the objective was to deal with that. This political uprising is not covered under that particular objective. One. Secondly, this is a political offense. As I gave you the context, the entire issue was political uprising against the party, a particular party, which is Sheikh Hasina's party. And secondly, whether it is done in the interest of justice and good faith. India has all these points, apart from the Act of 1962, Extradition Act of 1962. But if we primarily focus first on the treaty itself, it is a political uprising, and therefore it is not covered under the extradition treaty itself. Secondly, if you look at the entire, Yunus was anti-Sheikh Hasina. So the entire process which they have started, which they call it a due process, is not a due process. It is a political vendetta and retribution. So therefore, it is not in good faith. It is neither in the interest of justice. And secondly, if you look at the entire, facts and circumstances, India recognizes the crime against humanity for which Sheikh Hasina has been charged in the context of international tribunals, not domestic war crime court or tribunals.
Yes.
Now, what the Reuters says that this is a domestic war crime. There is no war. There are not two nations involved here. So India will not recognize the verdict of this. That is the possibility. It is the Ministry of External Affairs who is the central authority to decide on this. In Bangladesh, it is the Ministry of Home Affairs. So therefore, India is quite absolutely silent. Now, under 6.1 and 8.3 of the treaty, the two exceptions, as I told you, already exist within that. The political offense is an exception, and also if you look at the good faith and interest of justice is also an exception. The same two exceptions are given in the Extradition Act of 1962 of India. Right. An act should supersede, in the sense it is made by Indian Parliament, and as you said, discretionary powers of the Indian government, and within itself, Section 31 and 29 clearly point out about political exceptions and interest in good faith. And apart from the discretion, India can also abrogate the treaty by giving notice of 6 months. So all these facts are available, and the steps are available with the Indian government. Indian government, I'm sure, is studying the situation. Latest, warrant has been received.
Absolutely. Well, thank you so much there, Advocate Nikam, for putting all of these legal perspectives and the legal calculus, if I may, in perspective for all our viewers. Thank you once again.